Good morning, Your Honor. Natsume Asma on behalf of the people, B88493.
James Suzuki, on behalf of the defendant.
Mr. Martin. All right, Mr. Martin, can you tell me your first and last?
This isn't just another courtroom appearance. It's a full-blown collision between legal reality and sovereign delusion. Meet Mr. Martin, a self-proclaimed sovereign citizen who refuses to be labeled defendant, questions the court's jurisdiction, and fires his attorney mid-hearing. But it gets even better. He claims 30 years of legal training from a prison law library and insists he's ready for trial right now. The judge? Patient, but not playing. The public defender? Pleading for an exit. And the legal system? About to put this belief system on trial. Buckle up. This one's a masterclass in legal misunderstanding, courtroom control, and one man's refusal to play by the rules. Let's break it down.
Name.
First, I object. I'm not the defendant here.
Then I'm going to issue a bench warrant for your arrest. You're here. I'll recognize you. You're Mr. Martin. Okay. I understand. Let me ask a few preliminary questions. I know, Mr. Gazicki, you need to make a record. Is the complaining witness present for today's bench trial? Okay. Okay, thank you.
Two issues. One on discovery. We were here about 2 weeks ago. I did receive discovery. I believe it was like June 23rd or so on. I've been on vacation since the 3rd of July until yesterday. I had no opportunity to go down to the jail to visit Mr. Martin. But with, today, I handed him a redacted copy because according to the discovery procedures in Wayne County, the only files I can share with the defendant are redacted. As far as the video goes, I have no other means to, redact that, to show that, or to give him a copy. Today, I handed Mr. Martin a redacted copy of the police report that I did have. Okay. With that aside, Your Honor, I do want to make a motion to withdraw. I have had.
Here's our first major red flag. Mr. Martin flat out refuses to acknowledge that he's a defendant. Classic sovereign citizen tactic. The idea? If they don't consent to jurisdiction, they believe the court has no power over them. But courts don't play make-believe. The judge instantly shuts that down with a bench warrant threat. This moment sets the tone. Martin's playing from a script that doesn't match reality, and the judge knows it. His challenge isn't just legal, it's ideological. And that's where the real tension begins.
Contact with Mr. Martin in the past and ended up with the same position I am right now. There's no communication between the two of us. There's, different thoughts on how to proceed and so on that I cannot adhere to. So I'm asking the court to withdraw on this matter.
Mr. Martin, have you had a breakdown with your attorney?
No, he's not doing his job. So, like as he admitted, he hasn't brought me to discovery. So I just told him I'll file a motion to dismiss the case, then based on the ineffective assistance of counsel. Okay,
well, you can't dismiss a case on that. I'm asking you a specific question as it relates to Mr. Gazicki. Do you want him removed from your case?
As long as he's not going to do nothing that's going to jeopardize the case further, like try to delay, like he asked me, do you want to do adjournment? I said, no, I do no adjournment on the trial. I'm going to just sit in jail while I'm waiting. So I don't consent to him doing nothing that's going to jeopardize or violate my rights. But as long as he's doing, what he's supposed to besides it, I have no problem with it. But
well, you understand, Mr. Martin, I've told you this previously. Attorneys it's against the court rules for them to file frivolous motions. So Mr. Gazicki cannot, as your attorney, make motions that are frivolous. And some of the motions that you've previously presented to this court are in fact frivolous. Okay, I have jurisdiction. So if you're asking Mr. Gazicki to file a motion on the basis of jurisdiction, he cannot do that. Do you understand what I'm telling you?
But one, I didn't ask him to file a motion specific to no jurisdiction.
Well, you've asked him to file a motion to dismiss today.
No, I didn't ask him. I just told him I was going to do it myself. I was going to file the motion to dismiss the case because of this ineffective counsel not providing.
Okay, that's not a reason for a dismissal.
This is where the courtroom starts unraveling. The public defender moves to withdraw, citing a complete breakdown in communication. Mr. Martin's response? Not denial, just more blame. He accuses a lawyer of ineffective assistance and threatens to file his own motions. But here's the truth. Public defenders are bound by court procedure, and when a client demands frivolous filings, they're stuck. This isn't a disagreement. It's a collapse. The system's trying to help, but Martin wants to run the show on his terms.
Sure.
Okay, so Mr. Martin.
I'm gonna move up, well, if it's right now, I'm gonna move for that, that's why we're talking about it, or. a little
Okay,
later.
denied. What's your next one?
Based on what reasons?
Okay. So do you want Mr. Gizicki to represent you or not? Yes or no?
I'm gonna say no.
Okay, there's been a material breakdown of the attorney-client relationship based on both counsel and Mr. Martin's assertions. So Mr. Gizicki is withdrawn from the case.
Thank you, Your Honor.
Yep, thank you. Now, Mr. Martin, you have to make some decisions. Do you want an attorney appointed to represent you on this? I know you.
Unless one's immediately right now, no, because I'm not gonna allow a delay in this case due to,
Well,
these
Mr.
incompetent
Martin,
attorneys not doing their jobs constantly.
Mr. Martin, you have a constitutional right to an attorney. If you can't afford one, I will appoint one for you. Do you understand that?
I comprehend that, yeah.
Okay,
But-
so here's the thing. I don't want you to say that you don't want an attorney because you want to go to trial right now, unless you have a true understanding of what that means. Because you can't go back later and say, well, now I want to appeal because I wasn't given counsel because I said I didn't want counsel.
Watch how the conversation spirals. Martin talked about motions to dismiss, jurisdiction challenges, and ineffective counsel, but it's all misapplied. The judge calmly explains, motions must be grounded in fact and law, not ideology. Sovereign citizens often misuse legal terms, thinking it gives them leverage. In reality, it stalls proceedings and puts them at a disadvantage. The judge remains composed, but the subtext is clear. This isn't Martin's first sovereign stand, and the court is done indulging it.
Because I want to go to court right now. Do you understand that?
Well,
I'm happy to adjourn this for a week
but
so that you can have an attorney.
why I sit in jail, no, that's why I don't agree with that, so no, I can present myself fine, been doing all 30 years, studying, practicing.
Well, it's not been going very well for you, Mr. Martin. It might be time for you to get an attorney.
No, I don't agree with that, I've been beating several cases myself,
Okay.
so but regardless of that, this is a simple case anyways.
All right, Mr. Martin, listen to me. You understand. I want you to understand a few things, okay? Again, you have a right to an attorney at public expense. We could expedite this case and put it on a docket right away. It's a bench trial. So I could get you on, next week or later this week. I'm not certain if that's possible. It would likely be next week so that you could have a lawyer and that lawyer could represent you. And I want you to think about that because
Okay.
Mr. Martin, if you have a constitutional right to a lawyer or to represent yourself if that's what you want to do. But I need you to take the passion out of it, take the heat out of it for a minute and think about what you want to do as a smart decision. Do you want to wait a week for a trial and have an attorney present or not?
No, I don't want to delay this because there's no guarantee the next attorney may do the same thing, just keep on not doing their job and then think they're going to delay me, so no, I'm ready to go forward and I have,
You understand, Mr. Martin, that if you chose to represent yourself at this hearing, you're held to the same standards as an attorney. And do you understand that?
no, objected under Haynes versus Kerner, U.S. Supreme Court case. Pro se litigants are held to less stringent standards than formal pleadings drafted by.
This part's almost heartbreaking. The judge offers a clear path forward. Take a short delay, get real legal representation, and go to trial prepared. But Martin refuses. Convince attorneys only create delays. He's choosing speed over strategy, pride over protection. The judge even warns, you won't get to appeal just because you made a bad call today. Still, Martin barrels ahead. It's not just stubbornness. It's a belief system so deep, it blinds him to reality. And the court's patience? Running out fast.
Okay, well, this isn't a formal pleading. These are questionings of
Well, present
witnesses.
yourself the same
Well,
thing.
no, it's not the same. I want you to listen, Mr. Martin. I'm trying to make sure your rights are protected right now. I'm asking you to get an attorney. You've indicated you want to proceed without one. And I'm asking that you understand, I'm not going to allow you to get up here and ask questions in a way that are inappropriate to witnesses. You can ask questions, you can get answers, you can ask more questions, but I'm not going to allow this to meander into something that it's not. Do you understand that?
Well, I do my best. If it, if there's something, that comes that you let me know or whatever, but of course I know the basics of presenting a case, be it criminal or civil, so,
Did you go to college for 7 years to be a lawyer?
Not official college, but when I was in prison 24 years, I studied the law library for 24 years straight.
Okay.
30 years now counting, so.
Okay.
There might be a
That's
few
your
things I might
choice.
forget.
If that's, Mr. Martin, I'm not, look, you and I have gone back and forth for several hearings at this point. I'm not going to change your mind on things. I know that, right?
Right, yeah.
You have a right to a trial. You have a right to a trial by jury or judge. You've previously waived your right to a trial by jury. Is that correct?
Right, yeah.
Okay. And so
Martin drops a bombshell. He's been studying law for 30 years in prison. Sound impressive. Until you realize he's comparing jailhouse reading to a law degree. The judge tries to drive home a brutal truth. Self-representation is no joke. This isn't TV court. You're expected to follow the rules, question witnesses, and build legal arguments on solid ground. But Martin isn't hearing it. He's confident, even cocky. And that confidence, it's about to backfire.
Since I'm not gonna get a jury by like I really want, a jury of my peers to be those of the sovereign people, since that was denied before Slayton's court. Same.
yeah, do you know, where am I supposed to go to get a judge of a jury of sovereign citizens? I mean, that's not how it works. That's not what the Constitution requires. So you're waiving your right to a trial by jury, correct?
Only because, like I said, I can't get a jury by my peers of sovereign people.
Oh, okay. And are you waiving your right to an attorney?
As of now, but let's say, worst case, let's say even though I shouldn't, there's no evidence, even if it was to be guilty, I would then want an attorney to represent me on appeal, I'll say that. But
Okay, well, I want you to know that you would have a constitutional right to have that attorney too.
Sure.
And
But
if
as
you're
of now,
found-
no, because these attorneys keep, like I said, they keep doing this, it's
Okay.
constant.
Okay,
That I've been having, not doing their job and holding me up, I'm not.
Okay. All right. Is there another, Officer Frisky, Officer Kemp, can you come up for a second? If you can stay with the prisoner.
But also I need,
Here's where it turns surreal. Martin says he only waived his right to a jury because he couldn't get a jury of sovereign people, not citizens, but sovereign citizens. That's not how this works. The Constitution guarantees a jury of peers, not ideological clones. The judge tries, once again, to correct the delusion, but Martin doubles down. At this point, it's clear he's not playing a legal game. He's trying to rewrite the rules. And the judge, she's had enough.
Give me a second, okay?
Mr. Martin's hearing was more than a legal showdown. It was a live demonstration of how ideology can derail justice. The court tried everything: patience, explanation, offers of counsel. But in the end, Martin insisted on self-representation, rooted in sovereign citizen beliefs that hold no weight in court. The judge stayed calm, but firm, protecting the process, the law, and even Martin from himself. If you found this case as jaw-dropping as we did, hit that like button. Drop your thoughts in the comments, and don't forget to subscribe for more courtroom chaos, legal drama, and real-life consequences. This was one for the books.